This is Law Bites, a podcast with Michael Geist.
If you buy something, whether it's a tractor or a cell phone or a computer, you would think you have the right to fix it. Unfortunately, the companies would like to maintain a monopoly on repair.
It's the core problem that crosses all these industries, is that you don't own what you think you own, and you don't have the rights you're supposed to have.
We take offense to that, and we're trying to get our rights back. The basic consumer right to fix something that you own and not to be locked out electronically. And so right now, we're just hovering around in a gray zone, importing hack software from different countries, trying to fix their junk.
The right to repair, whether consumer electronics, farm machinery, or even health and medical equipment, is an issue that seemingly everyone can relate to. Given the implications for consumer and property rights, the sustainability of the agricultural sector, and protecting the environment, ensuring a right to repair would seem like an obvious political winner. Yet the issue has lagged, not the least of which is because of restrictive copyright laws that can limit the ability to repair personal property. Aaron Perzanowski is a law professor at Case Western Reserve University School of Law in Cleveland, Ohio, and the associate director of the Spangenberg Center for Law, Technology, and the Arts. Professor Perzanowski is the author of the forthcoming book, Right to Repair, to be published by Cambridge University Press early next year. He joins me on the podcast to explain why the right to repair matters, how copyright fits into all of this, and what reforms are needed to address the issue. Aaron, thanks so much for joining me on the podcast.
Yeah, it's great to be here.
Yeah, and it's a pleasure to have you on. First off, congratulations on the forthcoming book on the right to repair. It'll be published by Cambridge University Press in just a matter of months. And, you know, it's on a topic that I think we can all relate to. Repair is something that I think we've all had to experience. In my own case, sort of one of the more recent sources of frustration involved a very expensive oven range that I was told could not be repaired because the company simply ceased to produce the control panel that was needed to make this thing run. And there was simply no other alternative but to replace it, which was, bad for the environment and bad for my pocketbook. And so, I mean, that's pretty common though, I think. And few of us take the time though to think about the consumer rights issues, the environmental issues, much less the intellectual property, such as copyright issues that come up in these kinds of contexts. So, I'd like to explore all of those sorts of things, but wanted to start by asking, I suppose, what prompted you to write a book on the right of repair?
So, prior to this book, a lot of my research is really focused on questions of ownership, and especially ownership in a digital economy. So I wrote a book called The End of Ownership several years ago now with my frequent collaborator, Jason Schultz. And we covered a lot of those sorts of issues in a great deal of depth. And we touched on repair in that book, but sort of as the years passed, I thought the issue of repair really kind of deserved a fuller exploration. And as you mentioned, repair, it touches on the environment and consumer protection and IP law and antitrust and sort of the history of industrialization. And so telling that story really required sort of a book-length treatment rather than, say, writing a law review article or something along those lines. So I thought the book was really the only way to tell the whole story.
Okay, no, that makes sense. It's certainly for once people have the chance to take a look at the book, you were kind enough to provide me with an early version. It really does trace historically through so many of these kinds of issues. I thought we might get into some of the consumer concerns as a start, and then later get into some of the IP issues. And obviously, there's cost issues. There's how there may be deliberate design to create a limited lifespan on products. Now, your book emphasizes how this plays out in the electronic space with a particular focus on Apple. Can you talk a bit about those issues, especially when it comes to one of the electronics giants such as Apple?
Yeah, so Apple, I think, is representative of a lot of companies that make consumer electronic devices. I mean, the scale is different, right? Because Apple is just such an important player in that space. But Apple, like lots of other companies, has a really strong financial incentive to exert control over the markets for repair of their products, right? Apple wants to sell as many iPhones as it can every quarter. Apple does lots of different things. They make lots of different products. They're trying to, break into television streaming and music subscriptions. But fundamentally, Apple is a company that makes iPhones. That's where the bulk of its profits come from. And if iPhones are cheap and easy to repair, that means they last longer. That means we buy fewer of them. This is not a secret, right? Apple has admitted this basic logic in communications to its shareholders. When repairs increase, sales and revenue decrease. And so, as I said, they have a really strong incentive to convince consumers to buy new products and to buy them as frequently as they can. So Apple, like lots of other companies, they've developed a set of strategies that make repair less available, less attractive than replacing an old device with a new one, right? So part of this is about the design of the product. You use glue and you use solder, and you make it really difficult to replace components. You use exotic screws that make it harder to open up a device. Companies have started serializing parts so that they can't be swapped out. You can't just take an equivalent part from an existing device, plug it into your machine, and expect it to work. The economics here, I think, make a big impact. Companies oftentimes charge incredibly high prices for parts or for repair services. Sometimes, as you were describing, they just refuse to sell parts or perform repairs at all. That might be because they literally don't have the parts in stock, or it might be because of a company policy that says after 5 years or after 7 years, we've rendered these devices obsolete. And even if we could repair them, our policy says we don't. So there's a whole bunch of strategies that we see companies relying on out there in the marketplace that really make it difficult for consumers to avail themselves of repair, even if they want to.
Yeah, so that's the consumer side of the story, and as I say, I think it's one that a lot of us can relate to. One of the things that I think is really interesting about these issues, and we've seen it cropped up in Canada as part of the copyright issues that we'll discuss soon enough, is that it's been other sectors that have been just as focused on this issue. For example, the agricultural sector, the farming communities have been very vocal. In some ways, they've been the most vocal, at least in Canada, around the right to repair. Your book even touches on the delivery of essential services such as healthcare and how that can be implicated. Can you talk a little bit about how this is an issue that, one can understand how the consumer implications come to the fore, but it extends far beyond just that?
Yeah, I think this issue of repair touches on really every sector of the economy and every aspect of modern life in some ways. A lot of the techniques that I just described that enable these repair restrictions, right? Having functionality that's defined by software, having DRM locked component parts, those techniques are ubiquitous. We see them, for example, in agricultural equipment, John Deere tractors, for example. Farmers who want to repair their tractors themselves, or they want to rely on local repair shops that they may have utilized in their local communities for decades, for generations. Those farmers still have to pay the local John Deere dealer to come out to their farms and initialize authentic John Deere parts using proprietary software. So you're a farmer, you go out and you buy a component that you need, that needs to be replaced on your tractor. You put it on yourself, or you pay the local mom and pop shop to do it. It's not going to function until a John Deere technician comes with their laptop, connects it to your $1 million tractor, and basically blesses this new component, even though it's an authentic, OEM part. That I think demonstrates like the power that software really has to interfere with very long-standing practices around repair. We think of farmers as being largely self-sufficient. We think of them as being people that understand in a really intimate way how their equipment, how their machinery works. And despite that knowledge, right, they are prevented from engaging in this long-standing practice of repair. The economics are a little bit different in the agricultural space, right? John Deere, like your local car dealer, actually makes as much money or more money from service and maintenance than they do from selling new equipment. They know if they sell you a tractor for $1 million, it needs to last for a long time. They know it's going to need to be repaired. They're not trying to convince you to replace it with a new one every 2 years, the way Apple is with the iPhone. But John Deere wants to capture the value of that repair market for itself. And so you can see these strategies as a way to make that happen. As you mentioned, we've seen similar kinds of fights play out in the medical space, especially during the pandemic. We've seen ventilators and other essential equipment that needed to be repaired, but manufacturers simply didn't have the capacity to do it themselves. And so hospitals were relying on, independent third party, in some cases, medical technicians, but they couldn't get their hands on parts. They couldn't get their hands on software. They couldn't get their hands on diagnostic information that would have enabled them to easily keep these machines up and running. And so, it's one thing if you got to pay more money than you wanted to get the cracked screen fixed on your smartphone. It's quite another when we're talking about like genuine life or death situations where people are being prevented from repairing this essential medical equipment.
Oh, without doubt. I mean, the implications are enormous there. They're also really big, I think, from an environmental perspective. Obviously, this forced obsolescence means that there's a lot of perfectly good products that end up going into landfill, presumably, as part of this. Can you touch a little bit on some of the environmental implications of these essentially these kinds of systems that are leading to replacement as opposed to repair?
Yeah, you're right. I mean, the most obvious harms here are at the end of the product life cycle, right? When we replace devices rather than repairing them, that leads to more and more electronic waste. And the numbers here are like genuinely staggering. In the United States, we throw out something like 400,000 mobile phones a day in this country. Consumer electronics account for something like 50 million tons of waste a year. And electronic waste is particularly problematic, right? It contains like lead and arsenic and mercury, right? That's a real issue. Now, some of these problems, I think, can be addressed through increased recycling, right? Rather than things going into landfills. Companies like Apple are encouraging recycling because they want to reuse some of these components that are found in discarded devices. And that helps reduce some of the harms on the front end as well. I think, people forget that these, sleek electronic devices that we carry around in our pockets, the components to make them are, wrested from the earth, right? They're mined from this planet. And so, we produce something like 1.5 billion phones every year, and that requires mining gold and mining copper and a whole slew of rare earth metals that are really difficult to get at. And the process of mining and refining those materials is incredibly environmentally destructive. Not to mention, the smelters and the factories and the shipping vessels that we rely on to get these products into the hands of consumers. So it is like difficult to overstate the environmental harms. And I think that's something that a lot of us as consumers have like a vague awareness of, but I do think it's worth centering it in this discussion to really remind people of some of the kind of long-term stakes of these policy decisions.
Sure. So it is a really helpful discussion on both some of the environmental implications and as well as, of course, the consumer impact that this has. But, longtime listeners of this podcast will wonder, well, interesting enough, but, what does this have to do with some of the digital policies, the IP related policies that are typically a core part of the discussion? And in this context, we do end up with issues around copyright in particular, which may take some people by surprise, but it crops up in a number of different ways. Why don't we start with some of the discussion in the book around how copyright has been used to limit access to things like repair manuals or even in the naming of parts?
Yeah, so I'm a copyright person. That's how I came to this issue. And you're right, that connection, I think, is not immediately obvious to people. But the way I think about it is this: fundamentally, copyright and IP law generally, right? I talk in the book about copyright, but also, patents and trade secrets and trademarks and lots of other legal tools. They offer device makers really another set of strategies for restricting repair, right? Copyright is a tool, just like the design of the product is a tool that can be used to make repair easier or harder, right? Now, I'm doubtful about the ultimate merits of some of these copyright related tools, but they do get deployed. And as you mentioned, the first thing that we saw in this space was companies that tried almost always unsuccessfully to assert copyright in their part numbers. And so the thinking is, look, if you don't get the part, you can't make the repair. And so if we can control access to information about what part you need, either you're going to replace the device or you're going to come to us and buy it from the manufacturer rather than from a competitor. So they tried to exert control over those part numbers. The courts had different rationales in those cases, but almost always found that either the part numbers were unoriginal or they were the product of some unprotectable system or process. So that strategy didn't work out particularly well. What we've seen more recently is companies are starting to assert copyright in their repair manuals. So they will put these documents together that include step-by-step instructions for the diagnosis and repair of particular parts of a device. That issue came up in a really stark way when a company called iFixit, that sells replacement parts, but also creates and hosts a vast array of sort of user-generated repair processes. They created something called the Medical Device Repair Database, which was a collection of manufacturers' repair manuals for more than, I think, something like 13,000 ventilators and other medical devices during the pandemic. So they gathered all this information, they posted it online in order to make these repairs easier for independent medical technicians to engage in. And some of the companies said, look, we've got a copyright in that manual. We don't want it included in this database. If you've looked at these manuals, it's kind of tough to see the protectable expression in them. They are, as I said, a collection of step-by-step processes, processes that are typically outside of the scope of copyright protection. Even if there is a little bit of originality in the way those processes are written, you run into a sort of merger problem, right? How do we separate the underlying idea from the very limited forms of expression that will convey that process clearly? Some courts have even found that, straightforward photos or illustrations in the context of parts and manuals may not be protected. Nonetheless, these claims are being made, and in some cases have been made successfully, not litigated in court, but they've been asserted, and we've seen people remove material as a result. Now, iFixit didn't remove these manuals, much to their credit, but other people have felt that pressure and responded differently. And I think it's really important that we keep this information out there in the public, because without it, repairs are much more difficult to manage.
Sure. So, I mean, that in a sense, the restriction and access to something like a repair manual feels like for most more of a conventional copyright related issue, and you raise the kinds of questions that typically get asked in that context about what does copyright protect, and the implications of seeking protection for that kind of work. But even beyond that, and certainly in my own case, the way this sort of came to my attention has to do with anti-circumvention rules, which in Canada was a major source of concern. It was one of the lead issues when we reformed our law back in 2012. And there was, even at that time, much discussion about the implications around the implications for individuals and their rights to their personal property, and the implications it would have for consumers. Can you talk a bit about how anti-circumvention rules play into this issue, and why they have a real world implication or challenge when it comes to a right to repair, both for consumers as well as more broadly, as we talked about earlier, in areas such as in the agricultural sector?
Yeah, I think this is the key copyright issue in this space, right? And the concern here is that the functionality of all sorts of modern devices, right, from our cars to our home appliances, that functionality is defined and controlled by software. And typically that software is locked down in some fashion by a technological protection measure, right? That makes it harder for consumers then to diagnose and to repair their devices. And so those kinds of anti-circumvention rules that the US adopted all the way back in 1998, and that other nations, I think, regrettably have adopted since then, create potential liability, not for copyright infringement, right? Nobody's worried that you're going to download your microwaves operating system and put it on the internet for everyone to download and enjoy. But creates liability for simply kind of having the audacity as a consumer to take control of a device that you own. So if you remove or you bypass those digital locks, they're really designed to keep the consumer out of the loop of the device that they own. That is itself a source of legal risk. So to give maybe an example here, let's say you want to swap out a broken optical drive on your PlayStation, right? You go out and you buy the appropriate part, you install it correctly, but the device won't recognize that new part because there's something in the software that tells it not to. Now you might be able, and I stress might, you might be able to override that restriction, but doing so is going to require you to bypass the TPM that locks you out of the software, right? So there's nothing infringing about that behavior, but it does require the circumvention of that protection measure, and that creates a sort of independent source of legal risk.
Yeah. Does the same issue play out for the farmer that we were talking about earlier, that would want to repair their John Deere tractor, and runs into, again, the same kind of code, that if they seek to repair it, they have to bypass the code, that itself becomes this kind of infringement?
So there is the same sort of scenario playing out there. One way that farmers have been sort of forced to work around those restrictions is by downloading presumably illicit copies of John Deere's own internal software from the dark web, right? They're going to these Ukrainian websites and downloading what they believe to be the John Deere software so that they can now communicate with their own tractor. I think that shows kind of a level of absurdity here, that these are the lengths that farmers have to go to simply to repair their equipment with OEM parts, right? That's a real sign that something has gone wrong in the way these laws have been implemented.
No, I think that's right. And I think, thinking about it from a Canadian perspective, there is a recognition, increasingly anyway, that something has gone wrong. There were warnings back when the anti-circumvention rules were passed in 2012 that this was a likely outcome, almost an inevitable outcome, given how these rules play out. And so we've had a copyright review a number of years ago where there were recommendations to address the issue. We've seen provincial governments begin to pay some attention to it. And the Canadian government recently launched a consultation on some copyright reform issues that included this issue. So I'm curious about how other countries have sought to address these kinds of issues, starting, I suppose, with the United States. Have there been any carve-outs around some of these issues in the United States?
So when Section 1201, which is where the anti-circumvention rules kind of live in the US code, in the Digital Millennium Copyright Act, when Section 1201 was enacted, there was an understanding, right, that there would be a series of unintended consequences of this law, and that we wouldn't be able to imagine and to predict all of the sort of havoc that it might create. And so Congress included this rulemaking process, a rulemaking that takes place in the US Copyright Office every 3 years, the purpose of which is to identify potential exemptions from these anti-circumvention rules. So if you can prove to the Copyright Office that DRM is interfering with a lawful use of a copyrighted work, you can be granted one of these temporary exemptions. And that process has been going on every 3 years for more than 20 years at this point. And in the last few cycles, the Copyright Office has recognized that repair is a lawful use of software code. And so it has granted a number of fairly narrow but slowly expanding exemptions for the repair of vehicles and medical equipment, and most recently sort of a broad category of what they call consumer devices. And I think that's a very positive step in the right direction, but it doesn't fully solve the problem that we've been discussing, right? These exemptions are temporary. You've got to go back every 3 years and ask again. And as a person that's participated in this process, I can tell you it requires a lot of work. It requires a lot of time, and it is not an easy task. The exemptions are often typically quite narrow. So for the first time, the most recent exemptions, which just came out here a couple of months ago, they include video game consoles, but you're only allowed to repair the optical drive of a video game console. You can't replace the flash drive or the power supply or any other component that might need fixing under the scope of this exemption. And I think that the most important limitation to keep in mind here is that these exemptions only apply to the act of circumvention itself. They don't allow you to make or to distribute tools that enable circumvention. So that means that every consumer or local repair shop is supposed to figure out how to circumvent these technologies on their own. They can't simply download a tool that someone else created that does it for them. And as a practical matter, that puts a really important limitation on the benefit of these exemptions. I should also say the US has some permanent statutory exceptions in the anti-circumvention rules. But the ones in the statute, date back to 1998. They're sort of out of date in some respects. They're very narrowly tailored. I'd like to see a more permanent solution, not through this exemption process, but built into the statute itself, that provides a broad exemption for repair. There are some bills in the works in the United States that get close to doing that. And I believe there is a bill introduced in Canada that would do something similar. I think that's a better solution than this sort of, temporary piecemeal approach that we've been struggling with here over the past couple decades.
Yeah, I know from a Canadian perspective, there have been some private members' bills that have tried to move in that direction. And that's a response in part to the fact that we don't even have the review that you just described in the United States. And so it is open to our government to establish new exceptions. We do have some exceptions by way of regulation, but that's something they have never done in the nearly 10 years that this has been part of the law. So that without having kind of even something that every 3 years forces the issue to be revisited, very little seems to happen. Canada and the United States are obviously not the only countries that have anti-circumvention rules on the books. Are there other countries that have attempted to address this issue as well, especially that intersection between anti-circumvention and right to repair?
So I think the other example that's worth talking about here is Europe, right? So in Europe, the kinds of TPMs that we're talking about in this context, right, that relate to software fall within the scope of the software directive. And the software directive doesn't actually prohibit the act of circumvention. It prohibits the circulation of what it calls the means of circumvention. And so as we talked about a minute ago, circumvention really depends on the availability of these sorts of tools. So in Europe, we run into the same problem that we see in the US and elsewhere, which is that even though you might have the legal ability to engage in circumvention, that doesn't mean you have the practical skills or practical knowledge to do so. It's also worth noting that like Canada, in the EU under the software directive, there is no mechanism along the lines of this US Copyright Office rulemaking that would allow kind of newly arising problems to be addressed. I should also say, I think for anybody interested in kind of reading more about how these issues of TPMs and repair play out in Europe specifically, there's a great article by Anthony Rossborough called "Unscrewing the Future" that addresses all of these questions in detail, and that I found really helpful in my own research.
Okay, that's a great citation. I know Anthony's been active on on the Canadian perspective on those issues as well.
Yeah.
One of the responses that was raised back when Canada established some of the most restrictive anti-circumvention rules, really modeled on the U.S. approach, was that this was a requirement of the WIPO Internet treaties. And I know myself and many others argued that this was simply not the case, that there was far more flexibility built into the treaty. I guess I'm curious now that we've seen some attempts that to at least carve out some space in this area. Has there been any pushback from a treaty perspective? Was that just simply FUD or just simply wrong in terms of trying to claim that you needed something that restrictive in order to comply with the treaty?
So as far as I know, there haven't been any challenges claiming that any of the exemptions that the US has implemented through this rulemaking process violate their obligations under the WIPO treaties. And that's certainly not true for any of the repair exemptions. The language around TPMs in the treaty, I think, is fairly flexible if you read it, right? I mean, it basically requires adequate legal protection and effective remedies against circumvention. Like you, I don't think those obligations require the sort of, full bore approach of the DMCA. And I certainly don't see any reason that those obligations would be, inconsistent with exceptions that, basically permit what is otherwise lawful, non-infringing behavior, like repair. I also think it's important to keep in mind these anti-circumvention rules, at least initially, were supposed to have fairly narrow goals, right? They were supposed to encourage the digital distribution of music and movies by kind of backing these technological self-help mechanisms with some legal teeth. But that was a choice that has had, far-reaching unintended consequences, right? These rules, as they were, as they were advocated for at the time, they weren't meant to keep you from fixing your tractor or repairing hospital ventilators or, keep you from replacing the ink cartridges in your printers. The fact that these fights keep happening, that these issues keep rearing their head, I think demonstrates just how overreaching these anti-circumvention rules really are.
Yeah, no, I think you're right, and hopefully, Canada will think. Will be Canada and many other countries, I suppose, will think about the need to roll those back. I recall arguments around ensuring that fair dealing and some of the other user rights or exceptions were accounted for with the anti-circumvention rules, as well as, of course, some of the kinds of issues we've been talking about. Why don't we just conclude with this? At a certain level, one reads the book and here's what you have to say, and it's hard to see what the counter argument is. I mean, there's clearly, we're all consumers, we're affected. We've got important sectors, in some instances, life and death type issues being affected by this. The environment is being affected by this. There seems to be little reason not to address some of these issues, and yet it's been really slow going. Do you have a reason for that? Is it the companies themselves, that their self-interest, notwithstanding their professed concern for environmental issues, let's say, is such that the bottom line means that they've lined up to oppose some of this? Is it some of the copyright groups that don't want to see any of those protections chipped away, even if it doesn't make sense to apply it in this context? What do you think accounts for both the initial inclusion of these provisions in this way, but even more how it's been a real struggle to see them rolled back in a sensible manner?
Yeah, I think the opposition to making these sorts of changes comes from the sort of expected corners. As I said before, companies have a very clear financial interest in maintaining control over repair markets. There are absolutely certain copyright interests that are categorically opposed to any reform of anti-circumvention rules. I think out of some misplaced fears that might, eventually weaken the kinds of controls they have over, video games and other kinds of entertainment content. But I think it's also important to point out the way, and I agree with you, this has been slow going for a number of years. But I think the momentum is really starting to shift around this issue. And in part, it's because some of these same companies that have been the biggest opponents of the right to repair are really starting to see the writing on the wall. Last year in the United States, we had right to repair bills that were introduced in 27 states. The US Federal Trade Commission, at the urging of the Biden administration, has taken a much more aggressive stance on repair. In Europe, we've seen France introduce mandatory repairability scores for certain products. We've seen rules under the Eco Design Directive that have started to impose requirements on the way that products are actually designed. We see, Canada and Australia are both studying the impact of repair restrictions with an eye to some sort of reform. We see shareholders that are pressuring companies to make changes, and companies are changing. We've seen announcements from Microsoft, from Sonos, and I think most importantly, Apple, that they are willing to make changes around some of these policies. So Apple, as I'm sure lots of your listeners have seen, announced a couple of weeks ago that it's now going to start selling batteries and screens and cameras directly to consumers for iPhone 12 and iPhone 13 models. That's a huge concession, right? And certainly a step in the right direction, but it was motivated by a worry about impending regulation. So I remain kind of skeptical about what Apple's motivations are. We don't know what those parts are going to cost. We don't know what hoops consumers are going to have to jump through in order to get them. But I do see some encouraging signs that things are moving in the right direction. That's happening slowly. It's happening as the result of sustained effort from lots and lots of advocates in this space. But I think it's also a sign that, this is like a fight that's not only worth having, but one that's actually winnable. And for those of us that have been, paying attention to issues in the copyright space, winnable fights don't come around all that often. And so I'm really excited to see how this one plays out.
Yeah, no, this is true. But, I think we've seen that momentum. And I think that your forthcoming book really adds important fuel to the fire. It gives that kind of context that for some may be missing from both a historical perspective, and provides makes a persuasive case for why this is a trend that needs to continue, both in terms of what some of the companies are doing, but then even more what the need for legislatures and politicians to step up as well. Aaron, thanks so much for joining me on the podcast.
It was a real pleasure. Thanks.
That's the Law Bites podcast for this week. If you have comments, suggestions, or other feedback, write to lawbites@pobox.com. Follow the podcast on Twitter @LawBitesPod or Michael Geist @mgeist. You can download the latest episodes from my website at michaelgeist.ca or subscribe via RSS at Apple Podcast, Google, or Spotify. The Law Bites podcast is produced by Gerardo Lebron Laboy. Music by the Laboy brothers, Gerardo and Jose Lebron Laboy. Credit information for the clips featured in this podcast can be found in the show notes for this episode at michaelgeist.ca. I'm Michael Geist. Thanks for listening, and see you next time.